Hello everyone and welcome to chapter 12 of this lecture. So we're going to be covering half of chapter 12 on jurors and judges as decision makers. We'll stop at page 287 for those of you keeping track in the book. So we're stopping at jury deliberations. We'll pick up on that on Monday, and then remember Wednesday after that you all have an exam. Okay, so let's get started. Okay, so really in this chapter now, chapter 9 we talked about procedural stuff, mostly procedural stuff, and a few things about jurors specifically, their kinds of characteristics, their attitudes, and how that affects decisions. So now we're going to turn our lens towards things that actually affect jurors, okay, in terms of trial characteristics, defendant characteristics, stuff like that. Okay, so some of this is going to intersect a little bit with demographics or characteristics of jurors and also defendants and other kinds of case facts. Okay, so the next couple of slides are going to be covered, or things that are covered in chapter 9. So there's a little crossover here. Okay, but I felt like it fit better with some of this chapter 12 stuff. Okay, so this in particular is part of chapter 9. So go back and read about the similarity leniency hypothesis in chapter 9 to overlap with what I'm going to talk about here now. Okay, so basically, the similarity leniency hypothesis is specific to psychology and law, and it states that when jurors are similar to defendants on several, on certain characteristics like race, age, sex, whatever, then we think that they're more sympathetic or lenient to the defendant. That means that they won't convict. Okay, so a classic example of this, and somebody who coined the term similarity leniency, was Kerr and his colleagues in 95. And in one of their studies, they had participants who were either devoted Christians or Jewish students. Okay, and so they qualified this by looking at students who maybe participated in church activities on campus or off campus and things like that. Okay, so these were their participants, right? They were asked to provide a verdict in a child molestation case. The defendant was manipulated to be either a Christian or Jewish, right? So the person either matched or didn't match the defendant's faith. And so what you can see, get my clicker here, is that in this graph that was taken from their study, to orient you, they looked at the percentage that people voted guilty, okay? They looked at the participant's religion, so the mock juror was either Jewish or Christian, right? And then the defendant's faith. And so what you see in their original study is a similarity leniency effect. When participants were Jewish and they were judging the Jewish defendant, right? This line right here, Jewish individuals were less likely to convict the Jewish defendant, okay? But Christian jurors were more likely to convict the Jewish defendant comparatively. And the same could be said for the opposite. If the Christian individual was, well, actually I take that back, so sorry. The effect was higher, at least for between the Jewish versus the Christian individual on the Jewish defendant. Okay, and so this was an example, at least one example, of what we think is the similarity leniency hypothesis. Oh, come on. Sorry about that. I'm having some issues with the slides moving forward here. Okay, so that was their study 1. However, they wanted to correct for some issues and created a study 2. Okay, they also found a similarity leniency effect in their study 2. So again, this idea of being more similar would then result in leniency for the defendant. But in study 2, they also probed for this thing that they thought was the black sheep effect. Okay, and so this means that a person who is similar to you, who maybe is kind of considered the black sheep, like something negative has occurred or they caused something negative to happen, they're going to be punished more severely because the juror who's similar to them wants to protect their own relationship to the in-group, right? So if you're Hispanic, for instance, and the defendant is Hispanic, but they've done something really heinous and serious, and it's pretty clear that they did a bad thing, and through the evidence of the trial, then more likely than not, you're going to be more punitive towards them, even though you and the defendant are Hispanic, because you want to kind of distance yourself from that person, right? You don't want to, you're trying to let everybody know, like, don't judge me based off of my ethnicity, based off of this person's actions. He's not part of our in-group. We're going to distance ourselves. Okay, so an example of this is using case evidence or the strength of the evidence to determine this black sheep effect. So in ambiguous cases, we believe that similarity leniency is going to happen, right? So when jurors don't have a whole lot of evidence to go off of, the more similar the defendant is, the more likely they will acquit the defendant, right? They won't vote to convict. But if it's a strong case against this person, right, and that person is similar to them in some way, maybe by race, then yeah, we're going to vote to convict because we have to distance ourselves because the case is strong against them. So in Kerr's study 2, they did this, similar thing to study 1. They provided a verdict or asked jurors to provide verdicts in the child molestation case. The defendant was either part of their in-group or part of their out-group. So they had a mix of black and white jurors for this one. And the defendant was either black or white. So part of the in-group would mean if you were a black juror, and you were giving a decision about a black defendant, then the defendant is in your in-group. Okay, this is part of some group that you might feel that you belong to, right? Versus, for instance, out-group might be if you're a black juror, but you're making a decision for a white defendant. They're part of your out-group. Okay. And they also manipulated the strength of the case to make it weak versus strong. So now we have this split. This part of the x-axis is looking at whether or not the defendant was part of the out-group or the in-group of the juror. Okay, so they looked at both black and white decisions. And then the dotted line is strong evidence, the solid line is weak evidence. Okay. Okay. One last thing they were asked to do, or were told, they were led to believe that they were going to deliberate in this case, and particularly they were led to believe that they were going to have to deliberate without group members. Okay, and the reason that Kerr and colleagues did this was to ensure that people realized that they were going to have to defend their position, right? And so if the case is strong against this person, it's hard to vote to acquit and vote not guilty when it's strong, right? And in particular, if that person is an out-group member or an in-group member, excuse me, if the defendant is an in-group member and you're delivering with the out-group, you really want to make sure that you distance yourself from that in-group member who's on trial, who clearly did this terrible crime. Right? So what they found was evidence for both similarity leniency and the black sheep effect. So let's take the weak evidence first. In the weak evidence condition, when the defendant was part of the in-group, this bit right here, they rated the defendant less guilty compared to if they were part of their out-group. Okay, so they would have acquitted or voted not guilty more often if the defendant's part of their in-group versus out-group. However, when the evidence is strong against the defendant, you see the reverse effect. If that person is part of the in-group, right, if the juror is, deliberating on a case about a defendant who's similar to them, they're going to be more punitive, black sheep effect. They're going to vote to convict or, vote higher on their guilt score compared to if the defendant was an out-group member and the case was strong. Okay, so strength of the evidence can help us tease apart some of these effects. Ambiguous cases, you might be more lenient on the similar other. But when the case is strong, you're going to punish them more so if they're part of your group because you're trying to distance yourself from them. Okay, so the similarity leniency effect is actually not a really consistent effect, though. We've kind of talked about this a little bit with looking at, juror characteristics not being very predictive of verdicts. Well, the similarity leniency effect tends to be kind of wishy-washy. So, a meta-analysis done by Mitchell and colleagues in 2005 looked at a couple of different things. And for those of you who don't know, or maybe you need a refresher because I've talked about this a couple times before, meta-analyses basically look at specific kinds of studies that are pretty similar. They're similar in terms of um, the type of thing that they're looking at. So they might look at jurors' decisions based off of defendant race, right? So these meta-analyses will compile these results and look at the preponderance of the evidence. They'll kind of look at all these studies that look at the same factor, run statistical analyses on them, and determine, does more often than not this effect occur? Because we can find the effect, but if it only happens in a small percentage or proportion of these studies, then it probably isn't a reliable effect, or it might be dependent on other case facts. So in this meta-analyses, they did find a pretty small effect for juror-defendant race similarity, right? Because people can be similar in different things like religion. Race tends to be a little bit more consistent, so people judging defendants of their own race tend to be more lenient on them. But you still see some inconsistencies with this. Okay, Taylor and Hosh in 2004 looked at actual trials in Texas, in particular El Paso and San Antonio County. The jurors were mostly Hispanic and white, and they didn't find any support for similarity leniency or the black sheep effect. Okay, so again, there's some inconsistencies here and there. It might depend on the type of race, ethnicity that they're looking at. The majority of studies look at black-white types of comparisons, and so some of these might not extend to, Hispanics or other kinds of racial groups that are represented. And so Huntley and Costanzo actually found, and we talked about this a little bit in chapter 9, that sex can influence verdicts, so biological sex, so having a female juror and a female plaintiff, for instance, in a sexual harassment case. And so most of the time, females are more receptive to plaintiff's accounts of sexual harassment. So if the plaintiff, right, the person who is bringing or filing suit against some company or person, was involved in some kind of, was experiencing sexual harassment, female jurors are more likely to be more receptive to that. And it's this explanation. It's more about females are more likely to be receptive, and so then they'll be more in favor of the verdict. The demographics alone are not great at predicting verdicts. So just knowing that the person's female doesn't mean that they're always going to be on your side. It's more about what they believe or if they're receptive to these types of sexual harassment types of scenarios, right? Like they believe the woman more often than not. So sometimes, even though sex can predict that, it's not, it can also then be inaccurate in terms of predicting verdict. So another type of factor that might bias jurors or affect them in some kind of way is pretrial publicity. And so pretrial publicity is basically any kind of media coverage. Usually it's a high profile case before the trial begins, right? So the newspaper does a piece on someone and they talk about the crime. They talk about maybe things that cannot be entered into evidence at trial. So usually this pretrial publicity is negative in nature towards the defendant. In other words, it's biased to favor the prosecution. Okay, so a lot of the times pretrial trial publicity is kind of really making the defendant look more negative before trial, which can be unfair because jurors are supposed to be highly objective and be impartial and listen to all the case facts, and the defendant is presumed innocent until proven guilty, right? But that doesn't happen a whole lot. So pretrial publicity can do a couple of different things. So it can very directly kind of affect a juror's belief about whether or not the defendant's guilty. If they're exposed to negative pretrial publicity of the defendant, then before the trial starts, they'll be more prosecution biased. They'll be more guilt prone. Okay. Um, and this, I guess I should say, for anyone who wants to look up some good uh, articles on this, another meta-analysis was done by Steble and colleagues in '99. I know a little dated, but at that point there was a lot of pretrial publicity articles that had come out, and they did find overall that people exposed to negative pretrial publicity tend to be more conviction prone. Okay, they don't tend to disregard that evidence; they're kind of using it. Okay, and again, usually these people not only just believe that the defendant's guilty, they then believe the prosecution more, right? So those are two separate things that you can quantify. And so, for instance, if ambiguous evidence is presented at trial, maybe it's some kind of footprint analysis and things like that, maybe something that's inconclusive, jurors will interpret that as more supportive of the prosecution's case versus the defense case if they've been exposed to negative pretrial publicity. So that's problematic, and that kind of publicity can sway jurors on some really ambiguous types of information when it said you should probably get a 50-50 split if somebody was evaluating that evidence. In deliberation, right before deliberation, they maintain their pro-prosecution bias. So even after hearing all the case facts, right, some of it might be ambiguous, and they just kind of believe it to be supportive of the prosecution. Then through deliberation, they also show that they still have a bias towards guilt and a positive bias towards the prosecution. In other words, they support them more. And one really interesting thing that can occur, we talked about this when we looked at child interviews, if you remember. Negative pretrial publicity, can also affect jurors' memories. So if you read a media account of someone who's on trial for some kind of crime, you might incorporate into your memory some of the stuff that you read. And then at trial, if you serve as a juror, you might forget where you got that piece of information from, source misattribution or source memory errors. You might forget, oh, did I read about this in the in the newspaper, or did it come from the trial? You might mistakenly think that whatever you read in the newspaper actually came from the trial, but it might be inadmissible. It might be something that wasn't brought up in court and you shouldn't be using in your judgment towards the defendant. So this can be really problematic. And finally, in particular, emotional pretrial publicity can be really biasing compared to, and we'll talk about this on the next slide, more factual kinds of pretrial publicity, right? So talking about victims' injuries is more emotionally charged. So it arouses more negative emotions in people. And this can especially make people more guilt prone or believe the prosecution more. Okay. So a couple of solutions to negative pretrial publicity are things like ask the jurors to disregard any pretrial publicity they've been exposed to at the beginning of the trial. So the judge might instruct them to only use the case facts and disregard anything else. But this doesn't work as well. As you can see from the previous slide, of course this doesn't work well because people might be incorporating things into their memories from pretrial publicity, and they think it comes from the trial, but in fact doesn't. So a simple instruction like this isn't going to work. That can be problematic. Right? Some researchers have opted for, such as these gentlemen below here and ladies, to provide some time in between pretrial exposure and the trial. So participants might be given maybe pretrial publicity negative toward the defendant, and then 12 days later they're asked to read about the trial and render their verdict. And this 12-day delay seems to help work for certain kinds of pretrial publicity. So in particular, it helps work for more factual pretrial publicity. So things like a confession, prior criminal record, inadmissible but relevant evidence. When you give some time in between where the pretrial publicity maybe is talking about a confession, prior criminal record, all that fun stuff, and then you give some time in between that and the trial, jurors are less likely to then use that information and or convict the defendant. But for emotional pretrial publicity, this time does not help. Emotional pretrial publicity seems to do more damage. So if the mock juror reads information about the victim's injuries, even with a 12-day delay, they still tend to be more conviction prone. They're more likely to believe the prosecution more, and maybe even incorporate some of this information into their memory for trial. So the book suggests change of venue might be better because then there's a less chance the jury pool is exposed to negative pretrial publicity, right? And so this is yet to be seen. It's difficult to kind of evaluate something like this. And select for different people. But that's basically looking at our control groups, right? People who are not exposed to pretrial publicity don't have this kind of bias compared to those who are exposed to it. So change of venue probably works. They can move the trial to a different county or different place where people were hopefully not exposed to that kind of publicity. Okay, so those are just a couple of things that affect jurors, either kind of on the end of their own characteristics, like the similarity leniency hypothesis, as well as stuff before trial, pre-trial publicity, right? So now let's talk about how jurors make how jurors make decisions at actual trials. Okay, so there are two general schools of thought when people are trying to explain how jurors eventually come to their decisions. Okay, and so one of those is one of those ways that people talk about how jurors make their decisions come from mathematical models. So all of this is we think that jurors are making decisions by listening to pieces of evidence, giving them weight, right? Saying like, oh, okay, well, DNA evidence weighs more heavily in my mind than a confession or than, an eyewitness, okay? And then they put weight to it and then they move, towards guilty or not guilty based on each piece of the evidence. And like I said, they give weight to different kinds of evidence. Maybe confession evidence is weighed more heavily than footprint evidence or vice versa, depending on the juror, right? So an example of this is a theory called information integration theory, okay? And this basically states that jurors are affected by information that they're given throughout the trial, and they should move in the intended direction of the evidence. So they might have an initial bias to be pro-prosecution or pro-defense, and we'll see that with some data right now. And so, yes, people can kind of lean one way or another, and we can measure that with the PJAC, right? But they should still respond to evidence that supports the prosecution's theory by voting to convict more, or evidence that supports the defense theory, they're going to be less likely to convict after hearing that evidence. And so we tested that. Actually, a few of my colleagues and I looked at whether or not jurors are ignoring evidence, right? Because they can ignore some evidence if they're kind of already decided before the trial, or they can do what information integration theory says and move up and down on their conviction rating. So participants were given a PJAC in the study, and they were then asked to listen to a capital trial where they were going to sentence someone to life or death. Okay. And throughout the trial, as they were given various bits of information, like different kinds of evidence and things like that, they gave their sentence leanings at that point, on a continuous scale. So for instance, they heard an opening statement from the prosecution and then gave their leaning towards death or life. And then they heard the defense opening statements and gave their sentencing recommendation. And they also heard it after 3 experts that were either pro-defense, they were all defense experts. And then they heard the closing prosecution and closing defense statements, okay? And so what they found, or what we found, is yes, people do seem to have initial biases. So looking at their PJAC ratings, right, we did find that if you kind of follow along with the open circle guy here and the dotted line here, you can see that people who are pro prosecution are gonna they're gonna rate death as being their decision at that point of time more so than the people who have lower ratings on the PJAC, okay, the dashed lines, okay, with the X's here. And so higher scores just mean you're voting to convict, or excuse me, voting to die versus life. But if you look at the overall pattern of these, is even though people start off like this, after the opening prosecution statement, you see a spike in people wanting to sentence the person to death, right? So jurors seem to be adjusting their sentencing recommendations based on the evidence presented to them, right? So then after the opening statements of the defense, you see a decrease in this. Now they're less likely to vote to convict, or excuse me, vote to the person to the death sentence. And it keeps decreasing, or at least kind of stabilizes across the defense experts. And it dips up a little bit for some individuals and goes down for closing in the defense. So there is some reason to believe the jurors are paying attention in the trials, and they're not just kind of, oh, I'm, going to vote to die. I'm not going to listen to anybody else, right? So some evidence for some of these mathematic models. Another explanation for how jurors kind of compile the evidence and make their decisions are through, or is the explanation given through the story model. And so in the story model, this is originally put forth by Pennington and Hasty in 1993. They're basically saying that jurors create stories to make sense of the evidence that's presented to them. So based off of the evidence, they're going to make a story. And they can construct multiple stories. More on this later. So there are several stages of the story model, right? So jurors will create some kind of story based on the evidence, and they can have multiple stories. They'll learn about verdicts and kind of learn about, the different things that go along with if you choose to vote to convict or acquit this person. And then they reach their verdict by matching their verdict to whatever story it best matches, right? So whatever story makes most sense, they're going to then match it to whatever verdict makes sense for it, right? So for instance, if there's an ambiguous case where two guys are fighting, one stabs the other and kills them, one says it was self-defense, but other people or the prosecution is arguing it was not self-defense, then the juror, depending on the evidence presented to them, might feel like it was more plausible that it was self-defense. And if it was self-defense, that matches more so with acquitting, right? And so depending on, of course, the laws of the state. And so this is how it's believed that jurors make decisions. And this is usually the more widely accepted model of how jurors kind of aggregate all this evidence and information. They actually need to create a story. So whoever is the better storyteller and can really explain the evidence in a nice story that the jurors can understand and match up to a proper verdict is the one that's going to win out. So jurors should assess their own stories based on things like coverage. Does the story account for all the evidence presented at trial, right? So given all the evidence and the story that's kind of compiled by the attorneys, does all the evidence kind of fit nice and neatly into that story? If it doesn't, then the jurors are probably more likely to reject that story and accept the other sides, or maybe accept neither of them. They might look at coherence. Is the story consistent and plausible, right? If it's not plausible, if it's not consistent, then it doesn't make any sense, and that's not going to be the story that's chosen. If there are multiple stories that they construct that are plausible, then that's going to really affect jurors in terms of being able to select which one seems better, right? If they both seem quite plausible, then it lacks uniqueness. And so then they don't know which one to choose and might end up hung or not convicting at all. And finally, they might look at goodness of fit. So does the story fit with the verdict option, right? And this one's big. If you look at the beginning story of the Trayvon Martin case in your book in chapter 12, this kind of touches on this a little bit. The verdict that was, or excuse me, the charges that were given to Zimmerman, the individual who shot and killed Trayvon Martin, didn't really match up. Like, jurors felt like they could have convicted him if maybe the charge was lower, if the criteria um, for what he was being charged for was different, right? It wasn't intentional, but it was maybe negligent homicide, things like that. Okay, so goodness of fit with that verdict is important. And so it's tough to know. There's not a whole lot of research in this area, so for those of you future budding researchers out there, you can look how deliberations affect the stories developed by jurors, because right now, on an individual basis, we know more about how jurors construct this kind of story in their mind. We can analyze or ask them to report certain things to look at the types of stories they compile, but we don't look at how that might change after deliberations. And so, again, jury decision making versus juror decision making. Okay, so we talked about this before. Evidence strength seems to be the best predictor of jury verdicts, which is good. That might seem like a no shit kind of thing, like, oh yeah, duh. But we have to test this, right? We don't know if they are relying on the evidence, and it seems like they are, at least in strong cases. Talked about this last chapter, right? So when there's physical evidence present, maybe a confession, which we know there are problems with that. Eyewitness identification, also problems with that. But nonetheless, when there's more evidence against the defendant, they tend to vote to convict. However, I've been dropping hints at this, and I know it's kind of wonky the way some of these sections are split up, but if the case is weak, then something interesting happens, okay? Just like you saw before, we were talking about the similarity leniency hypotheses and some other stuff in chapter 9. When cases are weak, it's said that jurors are, quote, liberated, end quote, from only using the evidence, okay, because the evidence is limited, right? There's not much going on. So according to the liberation hypothesis, jurors are then liberated to use other stuff. You know, they're liberated from the constraints of the evidence, okay? So then they start to use extra legal factors to determine guilt. And sometimes this is called extra evidentiary factors. It's called by different kinds of names, but basically it's stuff that isn't pertinent to the case in terms of from a legal standpoint, right? So you should be only using the facts of the case to decide your verdict. So we've already talked about a couple of things. Negative pretrial publicity is an extra legal factor. The severity of the charge shouldn't determine whether or not you vote to convict or not, but it does. Complexity of the evidence at the trial, personal characteristics, their race, sex, SES, how attractive they are physically, and any prior beliefs or experiences that a juror has, right? So now you can think about the liberation hypothesis as when cases are weak, jurors are just looking to grab at anything to help them make a decision, okay? And this can be problematic. So strong cases tend to be decided quite fairly, but weak cases, ambiguous cases, we're going to start using some of these extra legal factors. Pretrial publicity, we've talked about race a little bit, and other kinds of characteristics that should not affect your decision. So now we're going to delve into that world. Okay, so let's talk about some extra legal factors. In particular, let's focus on defendant characteristics now. So we already focused on juror characteristics quite a bit and their attitudes. Let's look at defendant characteristics. So for instance, in civil cases, when corporations are being sued, juries tend to award higher damages, meaning they're making the corporations pay more compared to if it's an individual who is going to be paying these damages. Okay, and usually this is because they believe, jurors at least report that they think that corporations should be held accountable or held to a higher standard because there's more trust in them, right, to not be negligent. And it's also thought that because they're corporations, they have more resources and more money, so they can afford to pay. In criminal cases, non-capital offenses, in other words, cases that are not eligible for the death penalty, there's some inconsistent findings when you look at defendant characteristics predicting verdict. Just like with jurors, asking them to judge a defendant based on their characteristics tends to be rather inconsistent. But there is some evidence based off of Mazzella and Feingold's meta-analysis that more often than not, if a defendant is physically attractive, female, and high SES, socioeconomic status, that tends to decrease their chance of being found guilty. Okay, so it's beneficial, it's good for you if you're a defendant to be physically attractive, female, and high SES. Typically, again, this can be a little bit inconsistent at times and depend on stuff. For instance, if you use your physical attractiveness to commit a crime, people are going to punish you for that. So an example of this is, let's say the defendant gets close to a victim and has them place some large amount of money into, investing in some charity that they're involved in, but they end up swindling them and taking their money. If they use their attractiveness to get close to the person, usually this is seen as being manipulative, right? To try and swindle this person out of their money. And so people don't favor the attractive in that scenario. Interestingly enough, when you look at some other legal factors, right? So just to go back, that was some defendant characteristics. There are some interesting things that happen when you look at defendant and victim race. So obviously, jurors are sitting in the courtroom, and most likely they're going to know the race of the defendant and the race of the victim. So it's good to look at these together as opposed to in isolation. When you look at capital cases in particular, you see a pretty consistent effect when you look at both defendant and victim race. Death is more likely when the defendant is Black and the victim is white. And in particular also when the defendant is Latino and the victim is white. So when the defendant is part of these types of racial minority groups and the victim is white as well, you're going to see an increase of death sentences. Okay, and they've looked at this with real capital trial data and mock juror data. Okay, and so this might also be due to the fact that in real cases, prosecutors are more likely to seek the death penalty when the defendant is Black and the victim is white, or when the defendant is Latino and the victim is white. So it could start earlier than jurors. The fact that prosecutors are more likely to bring these cases to, or seek the death penalty cases, I should say, in these instances, means that then, there's going to be a higher percentage of defendants who get death because they're Black and Latino and the victim is white, or when they're, when those qualities are there. Okay, so this can be, really problematic. And some explanations for this, at least given by Hunt in 2015, are things like, well, there are differences between capital cases, at least when we look at the sentencing phase, versus non-capital cases where we're usually focused on looking at defendant guilt, because in non-capital cases, jurors they decide guilt, but they don't decide sentencing. Whereas in death penalty cases, capital cases, jurors can decide guilt and the sentencing recommendation. So there might be more of a focus on the victim when people are giving out sentences, death or life, because they have to think more about the value of the victim's life, right? They have to think, what does that, cost, right? And so that can change somebody's willingness or likelihood to vote for death or life, right? Also, death eligible cases, capital cases, tend to usually involve more violent interpersonal crimes. And a lot of these crimes tend to be stereotypically associated with Black or Latino people, like assaults. Violent crimes tend to be more stereotypically associated with Black and Latino people. So when you have congruency in stereotypes, then you are more likely to believe that that person maybe did it and maybe deserved it, versus if the defendant is being tried for a non-stereotypic crime, they might be less likely to convict them because it doesn't match their preconceived notion of what that type of person should be, what type of crime they should be committing. So some more dubious effects in capital cases. And another effect in the literature that seems pretty consistent, but at times we've had problems with is something called race salience. Okay, so this isn't in your book, but this is the idea that when race is made salient at trial, and this isn't just the mere exposure of people to a black or white defendant, this means the crime is racially charged or there's some racial elements to it. When race is made salient like this at trial, you get some interesting effects, okay? So for instance, I should say these weren't the first people who did the race salience types of studies. It was Summers and Ellsworth back in early 2000 and 2001 that looked at race salience, and people have replicated it since then. So Bucolo and Cohn had white mock jurors, and the key here is white. We'll talk about that. Read a trial and provide a verdict. The defendant's race was either black or white. Race salience was either present or absent. So the trial was made to be race salient or not. And this is how they manipulated race salience. The defense attorney in his closing argument said something like, the defendant didn't, what any black or white man in this situation would do, depending on defendant race, right? The only reason the defendant and not the supposed victim is being charged with this crime is because the defendant is black, white, and the victim is white, black. They always do the opposite race for the, or, quote unquote, opposite race for the victim, because that's where you tend to see more consistent effects, right? Just what we saw before. So this is an example of making race salient, right? You're bringing race into the equation in some way and making it more apparent in somebody's mind. And so what they found overall was that when race is not salient, people were pretty even in their verdicts, okay? So this was their guilt ratings, and between black and white participants, defendants, they didn't convict very much differently, at least not significantly so. However, when you make race salient, you see more leniency towards the black defendant, so they're less likely to convict them compared to the white defendant, right? So you can kind of look at this in two different ways. They're punitive maybe to the white defendant and or more lenient towards the black defendant. Okay, so in other words, race salience, making people salient of race, might actually help to reduce any kind of bias. But currently we're also seeing this kind of extreme effect where they might be punishing or being incredibly lenient to the black defendant and punishing the white defendant more, maybe kind of overcorrecting. Originally in Summers and Ellsworth's paper, they found that black defendants were convicted at higher rates than whites, but then you saw this effect disappear when race was made salient. And so now we're seeing kind of a more extreme flip these days. But some people still say that race salience can be an effective method to help reduce bias in decisions. Another thing to consider in terms of extra legal factors, right? These factors that jurors might use when cases are ambiguous is inadmissible evidence, right? So inadmissible evidence might be evidence that's stricken from the record, that might, maybe the lawyer was asking kind of a leading question or was asking a question that was not appropriate and brought up something that was not supposed to be part of evidence. And so a judge can tell the jury to disregard the evidence, but do they really disregard the evidence, right? So in the study by Pickle and his colleagues in 2009, participants heard a theft trial summary, and the witness in the trial said the defendant recently came into a large sum of money. So in the admissible condition, half of the participants heard that witness heard directly from the defendant say that he recently came into a large sum of money. In the inadmissible condition, the witness said that he heard this from another person who talked to the defendant, who heard it from them that they came into a lot of money recently. But this is hearsay. You have the right to face people who are accusing you. And so you, as a witness, cannot give any information that came from a third party. You have to testify to something that you directly saw or heard. Otherwise, it's hearsay. And so when it's inadmissible, it gets stricken from the record. Is it? And so the results of this, just to orient you all, Oh, and ignore my mistake here with ray salience. I was recreating some of these graphs. When the evidence was admissible or inadmissible, jurors did some interesting things in terms of their willingness to vote guilty or not guilty, their guilt rating. So higher ratings mean that they're more likely to convict or, provide a guilty verdict versus leaning less towards guilty. And so jurors are more likely to convict when the judge rules information is inadmissible. Okay, when they actually say, okay, they heard inadmissible evidence and they said, nope, strike that from the record. You should disregard that evidence. And if the statement tends to be unusual, okay, so they manipulated this by having the defendant kind of maybe say something silly sounding, like, he received all this money and, he's going to show me the money kind of thing, as opposed to just kind of simply stating that they saw the money. And part of the reason that they did this was because it has to be, again, kind of salient in your mind, this type of statement, and that might draw your attention to it more. And so if you notice, just to give you some idea, when the statement's neutral and admissible, it's allowed. They can use it towards their decisions, right? Then you see really that there's no differences or no significant differences between these two conditions. They rate guilt about the same. But in the inadmissible condition, in the neutral condition where the judge says, please don't, listen to that testimony, we're going to strike it from the record, you shouldn't use it in your decisions, it seems that the jurors are following through. They actually listen and say, okay, we're not going to, listen to that because it was hearsay and we can't use that in our decisions. And they were less likely to convict the person or to, vote guilty. And this is important because it does show that jurors at times can really listen to judges' instructions about the admissibility of evidence, but only when it was, a neutral statement where the defendant had maybe said something like, he acquired a lot of money recently and somebody else heard him say that, versus he's like, oh, I got a lot of money, and said something weird about like, show me the money, right, in the unusual condition. And instead, that seems to have what we call an ironic effect. People are more likely to vote guilty or give higher guilty ratings compared to the inadmissible conditions and the admissible conditions. Okay, so jurors also tend to use inadmissible information if they think it's fair to use it, like it's going to help them in their decision. So even though they can listen to judges, if they come across some information that maybe isn't hearsay but seems to be useful to their decision, they'll be more likely to use it. Okay. So these types of errors that people might make in terms of admissibility can be explained by a couple of different things going on. So one process is known as the ironic processes. And ironic processes are just really all sorts of fun. So when you're trying to avoid something, let's say you're trying to suppress a thought, okay, you're trying to not think about something. In a legal setting, that would be, let's say you're told to disregard some kind of evidence, right? You're told to disregard that statement. Well, a couple of things are going on. When you're trying to suppress a thought, one thing that's going on is you have conscious processes happening. So you are actively making sure that you're trying to draw your attention away from the thing that you're avoiding or the thing that you're trying not to think about and suppressing. So consciously speaking, you're trying to take your attention away from the thing you're supposed to avoid. There's also simultaneously an unconscious process occurring where your unconscious, right, your unconscious mind is actively monitoring for the information that you're trying to avoid or you're trying to suppress. So instead, it's kind of doing the opposite of what you want it to do. So what ends up happening is the unconscious processes, because they're searching for that information, they're monitoring it for it unconsciously. That's happening so that your conscious processes can avoid it, right? So it's trying to inform your conscious brain, hey, we're supposed to stay away from this stuff, but it's doing it on an unconscious track. You're not aware of it. But the problem with this is these unconscious processes tend to actually increase the availability of that information in your mind. Because they're focusing on it and they're actively monitoring for information or things that you're supposed to be suppressing, it's actually making it more readily available in your mind. And so you're more likely to, actually do the opposite and think about that information more so than not. So an example of this is Wegner in his study had people, basically try not to think of a white bear. They were instructed, don't think of a white bear, but found that by giving them the simple instruction, people actually thought of a white bear more often than if they weren't told this statement. So again, this is an ironic process, right? Because the thing you're trying to avoid actually comes to mind more often. Don't think of a white bear, you're going to think of a white bear more often. Okay, so that's the fun time in ironic processes. So if let's take that back to juror decisions and being told not to listen to that evidence, right? If you're told, don't think about this evidence, well, it's going to be really hard not to think about it now because you've brought it up, right? This might be one reason why jurors use it more often, and it becomes this ironic process. Reactance theory is also another explanation, albeit not a great one. There are problems with reactance theory, like it's not well replicated, and it's kind of hard to falsify. But reactance theory by Brennan Brehm suggests that people like their freedom, they're motivated to keep their freedom. If you're told not to do something, you're going to do it. So if you're told you can't use this evidence, you might say, well, you can't tell me what to do. I'm going to use this evidence, right? So you can think of teenagers, rebels, in this instance of reactance theory, psychological reactance. Okay. So these are just a couple explanations. I think ironic processes are probably a better explanation because there's more evidence to suggest that this occurs, that our thoughts of a certain thing we're trying to avoid actually increase after we're told not to listen to them. Okay, last couple of things. Another extra legal factor that jurors might glom onto, might use when they're not supposed to, right, is impeachment evidence. So impeachment evidence is any kind of evidence that might be brought up at trial to try to maybe discredit or somehow damage a witness, right? So if you damage their credibility, then maybe in the jurors' eyes they'll be viewed as less believable and they won't be used as much. Their testimony, what have you, right? So in general, just to kind of back up for a second, jurors tend to use evidence that indicates a propensity for criminal behavior. So